Hi, everybody. As promised, I'm going to record a very short session on the WTO dispute settlement as we didn't have time yesterday to finish. We talked a little bit already during the class about the dispute settlement, but I just wanted to give you a few more details about the objectives and the functioning of the dispute settlement system that was created in 1995 with the creation. It is a very sophisticated and efficient system, in particular compared to the dispute settlement mechanism that characterized the GATT era. We talked about it at the beginning of our session yesterday. We saw that it was quite weak, in particular because all the parties, including the losing party in the dispute, had to agree to adopt the report of the panel of experts, which of course, would happen very, very rarely. Now, the new system was introduced in 1995 together with the creation of the WTO and everything else that we have discussed yesterday about the results of the Uruguay round between 1994 and 1995. It was so successful and so sophisticated, the system of WTO dispute settlement, that it was always considered as the jewel in the crown of the WTO, as its pride. As I mentioned already a few times, and that we will see in a few minutes, the system is today in crisis. Now, one of the unique features of the system, we'll see that there are several unique features of this dispute settlement system compared to others that you may be more or less familiar with, is that as it was conceived, it had a first layer with the establishment of a panel of experts composed of 3 experts, trade experts, that had to be impartial and they couldn't be of a nationality of any of the parties to the dispute, created just to settle a specific dispute, and that would be dissolved after it finished its work and produced its report. What is interesting is that the parties to the dispute could then decide to appeal this report to an appellate body, which is a standing permanent body of 7 judges, 7, again, trade experts that are nominated by consensus by the membership of the WTO. So these 2 instances, a panel first and appellate body second, this is quite unique because you don't find in international law other courts or tribunals whose decisions can be appealed, while this is absolutely normal in domestic legal systems. Now, the main object and purpose, and we find here already, if you look at the functions, we saw this slide already yesterday, Article 3 of the WTO agreement, which lists all the functions of the WTO. One of them is to administer what we call the DSU, the Dispute Settlement Understanding, which is that agreement that deals with all the rules that have to do with dispute settlement. And if you remember this other slide that I showed you, one of the annexes, in particular Annex 2, is precisely the DSU. So contains these rules that basically tell us how dispute settlement functions and works at the WTO. There you go. You can find the text on Moodle. Now, in particular, you can see here at Article 3 that there are some very specific objectives of the dispute settlement system at the WTO, which is, in general, to ensure a peaceful, positive resolution of a dispute. More broadly, as you can see in paragraph 2, this is part of, the idea of providing security and predictability to the multilateral trading system. And also very important, and I mentioned this already yesterday, to preserve the rights and obligations of members under the covered agreements. And the covered agreements are all the multilateral agreements that we find, in that big chart. It has to preserve the rights and obligations. So the panels and the appellate body cannot add or diminish rights and obligations that we find in this agreement. And then the second part, we have already read it together yesterday. They have to clarify the existing provisions in accordance with customary rules of interpretation of public international law. So yesterday I used the example of the US shrimps case to show you how the appellate body has relied on Article 31 of the Vienna Convention on the Law of Treaties to interpret existing provisions of the GATT or of other agreements of the WTO. But what is very important is that by doing so, the appellate body should refrain from exercising judicial activism. So to go beyond what is simply the task of clarifying and interpreting and creating new rights or obligations. And I mention this because this is precisely the criticism that was made to the appellate body by certain countries, by certain members. They were arguing that the appellate body was doing more than what it was supposed to. It was actually creating new rights and obligations. And then the result, in particular, the member that was particularly, wasn't the only member that was particularly vocal, was the United States. And the way in which they decided to handle the situation was to basically block the appointment of new members of the appellate body. So you have 7 members of the appellate body. Each has a mandate of 4 years, which can be renewed once. At some point, one of them was ending the second mandate. The United States blocked a new appointment. And then as years passed, they blocked all the other appointments until we were left with 0 members of the appellate body. And because consensus is needed, 1 member is sufficient to block appointments. So now the appellate body doesn't really operate, doesn't really exist, and we will see what are the implications. Now, a few words on the jurisdiction of the dispute settlement system. So, first of all, a wide range of matters can be brought. In particular, any possible violation of what we call the covered agreements. So when you hear or when you read this term covered agreements, here it is. You go to Appendix 1, agreements covered by the understanding, and you have your little list. Of course, you need to keep in mind when it comes to the plurilateral trade agreements that will only be the case for those members of the WTO that have decided to ratify those specific agreements. Now, the dispute settlement system at the WTO has 3 very particular features. The first one is that it has compulsory jurisdiction. Compulsory jurisdiction, which is something that, again, for those of you who already have studied public international law, you know that generally international courts and tribunals do not have compulsory jurisdiction. So states have to give their consent to go to that court or tribunal. Usually, the consent is in a treaty clause. Here, there is compulsory jurisdiction. As soon as a country is a member of the WTO, because of the single understanding, the single package, there is compulsory jurisdiction. So they basically agree ex ante to accept the jurisdiction of the WTO dispute settlement system for any violation of the covered agreements. So it's compulsory jurisdiction. They can't refuse or opt out from this jurisdiction. That's the first important feature, compulsory. Second feature, it's an exclusive jurisdiction. So you want to complain about a violation of one of these agreements, you can only go to the WTO dispute settlement system. You can't bring this dispute to another tribunal. And then a third feature is that it's only contentious jurisdiction. So it can only solve disputes. It cannot issue advisory opinions like many other courts and tribunals do. So keep in mind these 3 features of the jurisdiction: compulsory, exclusive, and contentious. Now, when it comes to the access to this dispute settlement system, it is only states. So it's a state-to-state or interstate dispute settlement system, like the ICJ, like ICLOS. So it has to be a state bringing a dispute against another state. NGOs, individuals, corporations do not have access. So it's very different, for example, from investor-state dispute settlement that we will study in the second part of this course, or it's different from human rights litigation, which you might have studied in other classes. Now, just because it's state to state and just because only states have access to the dispute settlement system doesn't mean that, in particular, lobbies, industries, and corporations do not have an important role to play. In fact, most of the times, there is a group of companies, there is a lobby of industries behind the dispute. Because usually what happens is that a certain industry, let's say that the steel industry in a country is all of a sudden hurt by very cheap imports from another country. They feel that maybe that country is violating some WTO rules, and so they go and put pressure on the government to bring a dispute. And just to give you an idea, there are some very famous disputes. For example, there is a dispute called tobacco plain packaging. Australia tobacco plain packaging, which is a dispute that was brought by Indonesia against Australia because Australia had introduced a law that imposed plain packaging rules for cigarettes. So all cigarettes packets, for example, had to remove all the logos. So the name of the brands had to be in the same font, same color, without all the logos. There had to be these very kind of scary pictures of health disease that can come from smoking. The title is tobacco plain packaging, but we all call it the Philip Morris case because it was actually Philip Morris that was hurt by this measure and that went around and looked for a country that was willing to bring the dispute against Australia. Or there are two disputes brought, one by the EU against the US and one by the US against the EU, and that are called the large civil aircraft disputes. We usually call them the Boeing and the Airbus disputes because those are the two companies that are behind the dispute. So just keep in mind that there is always this strong pressure from corporations, although who formally can have access to the dispute settlement system is only the state. Now, the organs that you have, and I think you should have, yes. So we go back to this chart with the institutional structure. Remember, we talked about, well, the ministerial conference and then the general council. The general council has two alter egos. So the general council, which is made up of ambassador level representatives of all the members, can meet as dispute settlement body to discharge its functions related to dispute settlement. For example, it establishes the panels, it adopts the reports of the panel or the appellate body, it supervises the implementation and does a few other things. And then, of course, you have independent bodies that are the panels and the appellate body. As I mentioned, the panels are ad hoc, so they are created just to deal with one specific disputes, composed of three experts. There is like a long list, and then the parties can pick, who they like. They can't be from their nationality. While the appellate body is this standing permanent body that ideally has seven members. That right now is not really there. Now I want to tell you a little bit about the procedure. Now this seems like seems very complicated, but I just want to guide you quickly through the procedure. There are four main phases. The first one is consultations. Generally, in dispute settlement, we try to start with consultations. So before getting to a formal dispute, this is not unique to WTO law. Consultations, what does it mean? Negotiations. So usually the party that is complaining sends a request for consultation to the other party to try and talk it out. Now, if the other party doesn't respond within a certain amount of time, then the complaining party can simply request the establishment of a panel. But if the respondent does respond to the request for consultations, that consultations happen for 60 days. So you have 60 days of consultations. And this is very important. It's a very important phase. It's, 1 out of 5 disputes end at the consultation stage. So they can be very successful to actually bring in the dispute to an end. So it doesn't even become an actual dispute. But even when they're not so successful, they're still very useful because it's still a good moment for the two countries to kind of get a better understanding of what's going on, try to test and see the strengths and the weaknesses of their positions, of their arguments, and even narrow down and limit the scope of their claims and their defenses. So it is a very useful exercise. So if it doesn't work out, we get to the second phase, which is the panel proceeding. So all the proceedings before the panel. And again, I'm not going to go into all the details here. You have what I like about this chart is that you have all the different articles. So if any of you is particularly excited about this and you want to go, you can, for each little phase, you have an article of the DSU that tells you exactly, how it's established, what are the terms of reference, and so on and so forth. So the panel is established, you have the panel proceedings. What is interesting, the one article I want to show you is Article 13, because the panel can seek expert advice. A lot of these cases, in particular because the panel proceedings, I should clarify, deal with issues of both fact and law. And in particular, the issues of fact can be very, very technical. So they often, they have the right to request and to seek information from experts. But as you can see, it's full discretion of the panel whether and how they want to involve experts. Now, once this panel phase is done, and you have, here you have all the different duration of each phase, the panel prepares a draft report, shares it with the parties. The parties can provide some comments, and then the final report is shared with all the parties and with the rest of the members. Now, from that moment, any party has 60 days to appeal, which means that if it doesn't happen in 60 days, then the report is adopted by the dispute settlement body. If instead a party decides to appeal, and this again, I'm telling you that, how the procedure works in a normal situation when the appellate body was still active. Parties could appeal. And then you have the third phase, the third phase, which is the appellate proceedings, the appellate review. Now, what is important to note here is that the appellate body can only review issues of law, not of fact. So it cannot work with the facts, but only issues of law. And in general, the appellate body can do three things. One of three things. It can uphold the decision of the panel, for each claim. It can modify or reverse. And we have quite a few situations where some of the most famous decisions of the appellate body, some of which I assigned as readings, the appellate body has completely disagreed with the analysis or with the outcome of the analysis of the panel and has reversed the findings of the panel. Now, what happens now? Now that we don't have an appellate body, what happens is a little tricky because the rules are still there. So the parties can still appeal. They're still allowed to appeal. But the problem is that, and if they appeal, then the dispute settlement body cannot adopt the panel report. But they appeal, how we say it, in the void. So they appeal in the void. There's no appellate body to judge those appeals. But because there is basically a paused appeal until we might have one day an appellate body, the panel report can never be adopted. And therefore, it's basically, it does nothing. It has no implications for the parties. And a lot of these panel reports are being appealed in the void. There are also a few panel reports, and if you listen to the podcast that I assigned for 2 weeks ago, for last week, Emmy Porgis talks quite a lot about this. There are some countries that, because of the kind of relationship, the diplomatic relationship they want to maintain with the other member, they might decide to not to appeal, and so to have the panel report be adopted and try to comply. But let's go back to a situation where the appellate body is there. So in the past, they would prepare the report, and then the report of the appellate body and the report of the panel, as upheld, as modified, or as reversed by the appellate body, would be adopted by the dispute settlement body. And then it's with the adoption by the dispute settlement body that it becomes binding on the parties. And then we get to the last phase, which is the implementation. Now, the main goal is for the country to comply with the decision. And what the losing party has to do basically is to put its laws and regulations in compliance with the decision. Simple as that. You will see it's very different from investment arbitration. We will see in investment arbitration that if a state loses against an investor, the state is going to have to pay. Here, no, it's just about modifying your internal laws and regulations in a way that makes them consistent with the decision and therefore with WTO law. Now, of course, it can, and there is again, the party has a reasonable period of time, which is different, for example, depending on whether it's a developing or developed country. The winning party, if the winning party feels that the losing party is not implementing the decision, then the winning party can basically launch a compliance dispute, which follows exactly the same path as so the panel and appellate body. This is it's on the basis of Article 21.5 of the DSU. You might find some decisions where you have the same title and then 21.5. It means that after the panel, after the appellate body, the winning party feels that the losing party is not complying and brings a dispute to find non-compliance. Again, the overarching goal is compliance, is that the losing party, the party that is not complying, finally complies with the decision, and so puts all its laws and regulations in line with WTO law. There are also some kind of temporary measures that the winning party can ask the dispute settlement body. The first one is compensation, so to negotiate an amount to be compensated. And the second one is the possibility to retaliate, which basically means to be able to adopt a measure that it can be, for example, a tariff or another measure to countervail and counterbalance the economic impact that the winning party is suffering. But again, the overarching goal is compliance, is to ensure compliance. Things I want to tell you about the dispute settlement. First of all, the role of developing countries. Now, developing countries they actively make use of the dispute settlement system. But of course, the level of knowledge, of skills, of expertise is different. And that is why if you go through the dispute settlement understanding, you will find that there are special rules for developing countries or for LDCs. Something that is, at some point in time became quite clear is that legal assistance is very expensive. And so here in Geneva, we have a center, it's called the Advisory Center on WTO Law, ACWL, which, by the way, for any of you who are interested, would be like a nice place maybe to do an internship or even for career opportunities that provides legal assistance to developing countries, and it's entirely funded by developed countries. So there are a few things that happen to facilitate the use by developing countries of the WTO dispute settlement system. And then the last thing is what is happening during this crisis of the dispute settlement system. So one thing, I already mentioned it, there is this situation of the appeal in the void. So some countries do appeal decisions in the void, which means that the panel report will never be adopted. Others decide to not to appeal. A few countries have come up with another solution. They have come up with another solution, which is the creation of the multi-party interim appeal arbitration arrangement, or MPIA. I actually think that this is a little bit old because, if I'm not wrong, I will check for next time, but I think that there are more than 57 members now to the MPIA. I should check. So here you have the list of the members. So this basically is a form of arbitration. On the syllabus, you have a link to a very nice page that explains very well how it works, and so on and so forth. It's basically a form of arbitration that can serve as an appeal system for decisions of the panel, but only when both parties are parties of the MPIA, so both parties have joined. One important difference is that the decision, the report of this arbitration procedure does not have to be approved and adopted by the dispute settlement body. But then many other aspects, in particular when it comes to implementation and enforcement, follows the same exact rules as the appellate body. So there are a lot of overlaps and similarities in the procedure. And there are a few on the website. You can also find on the web page that we added to the syllabus. You can find also what are some of the disputes that currently the MPIA is discussing. This is it. Just one final thing that I wanted to show you. Voila, I want to show you something else. I want to very quickly show you the web page of the WTO. And that is just always in this idea of discussing the dispute settlement system. So overall, this is a very useful website. You can find a lot of different things. When it comes to disputes, you can click here on trade topics. And then you have all this area, dispute settlement, and you can do a lot of different things. You can search for disputes. Let's say that we want to go to find dispute cases. You can select, you can find different ways to find and to select disputes. Now, I talked to you yesterday about the gasoline. So let's look for that. Let's search for disputes from a lot of very important disputes in 1996. Let's go to our gasoline, should be or you know what, we also have shrimp. We can use this one. So you find your dispute. Oh no, it's not the one, sorry. You see, when you do things like that, search, we can actually find any. We can do hormones. So it's quite interesting. You can find a lot of information about the case. Here you have hyperlinks that take you to all the documents, the appellate body report, panel report. You have here a little summary. What I like to show you that you can use is that you usually have a one-page summary of key findings. And this is quite nice because, as you see, you have all the key information, the parties, the agreement, the kind of measure, and you have a very good summary of all the key panel and appellate body findings. So just for you to know that this is a tool that exists, which I think is quite useful. In general, you can have a look at the website of the WTO. You can find a lot of information. You have access to all the agreements and a lot of other things. I'm going to stop here. If you have any questions, please write me, or we can talk about those next week.